Mike, check, check, check. Justin Hunt. It's all happening. Thank you to everybody rocking with the channel. Thank you to everybody subscribed through the channel who shared a video, shared a link. It's priceless. Big thank you to everyone who's donated. If you'd like to donate, you hit the Cash App that's right up there or the link in the description. I'm going to jump right in today. We have a long update. So this week, Drake's legal team filed a memorandum of law in opposition to defendants' motion to dismiss the amended complaint. So this is the update on one of the biggest stories of the year, which has been Drake taking legal action against UMG, suing UMG for defamation over Not Like Us. And so we've covered pretty much every step of the way. There's a couple of things that happened that we haven't talked about on this channel. There's a couple of amicus briefs, for example, that were filed. One of those will be referenced in here. But for the most part, we've been covering all the legal documents pretty much all the way through. 1 second applause to all y'all for sitting through this. But this is a case that will have broader ramifications, or could have broader ramifications, on the future of rap battles. I would describe what happened between Drake and Kendrick more as rap beef and not a rap battle. We can see that Drake ain't gonna leave here with something. He's leaving here with something. He told himself he's leaving here with something. If I can't win a battle, I'm gonna see if I can, if I can get paid. That's my phrasing. That's not Drake's phrasing. They're saying that he was defamed by Not Like Us. And so where we last left off with this was UMG filed a motion to dismiss. So this is Drake's team's rebuttal to that motion to dismiss. Okay, so we're going to jump right in. We're going to take a look at it. But I do want to say thank you to everyone who tuned in to Culture United this week. It was a great conversation, focused largely on things that we could never see again because of this legal case. Joey Badass versus everybody, particularly Ray Vaughn, Daylight, and a number of talented artists from the West Coast, even though it's not a West Coast versus East Coast thing. And it ended up being a battle royale that had 60-something artists, and over 100 songs made on this one topic. So big shout out to Bad Drew, big shout out to Jeremy Hecht, big shout out to Mr. Mecca, big shout out to Curtis King, big shout out to Screwface John, and big shout out to FD Signify for joining that discussion. So 1 second applause to all of them. All right, so let's jump right in here and let's take a look. Let's see what Team Drizzy talking about today. Team Drizzy talking about today. So here it is. U.S. States District Court, Southern District of New York, Aubrey Drake Graham, plaintiff versus UMG Recordings. Plaintiff's memorandum of law in opposition to defendant's motion to dismiss the amended complaint. So this is what we're going to take a look at today. All right, table of contents. We can skip that. Look at all these contents they have. So many contents, so many SKUs. It's like Target, so many SKUs, so many products. All right, so here's the preliminary statement. We always read this. Then it's going to go in the background. I'm going to skip that because every piece that I've done on this has pretty much the same background. And this background hasn't changed since they filed their amended complaint, which was the last thing that UMG filed. After the amended complaint, Drake's team, UMG filed a motion to dismiss. And now Drake's team is saying, wait, this is their rebuttal to the motion to dismiss. Plaintiff Aubrey Drake Graham, plaintiff or Drake, respectfully submits this opposition to UMG Recordings motion to dismiss plaintiff's amended complaint and request for judicial notice. Preliminary statement. The primary question raised by UMG's motion to dismiss is going to say MTD. Sometimes I might go back and forth between MTD, but MTD is motion to dismiss. And they're also going to say AC. AC is amended complaint. So that's the last thing that UMG filed. UMG's motion to dismiss is whether Drake's amended complaint plausibly alleges that a reasonable listener could have concluded that Not Like Us and its accompanying cover art and music video were conveying facts about Drake. Davis versus Boheme. The amended complaint does not just allege that reasonable listeners could have reached that conclusion, it plausibly alleges that millions in fact did so. As the alleged amended complaint alleges, the unmistakable message conveyed by the recording, image, and video is the indisputably false allegation that Drake is a certified PDF. The recordings call for violence against Drake, and the image offers aspiring assailants a map of where to strike, an overhead photo of Drake's actual Toronto home, plastered with icons known to identify the location of Child S offenders. The footnote here says, terms not defined herein have the meaning in the amended complaint. UMG's theory is that all of this was hyperbole, a harmless joke that no reasonable person would take seriously because it was part of a rap battle. Quote, put it in quotes. Now, this may be the first time that I remember seeing Drake's team even mention rap battle. So they put it in quotes here, but this could be the first time, I think, in one of their filings that they've said that, which is crazy. But this is how myopic they need this lawsuit to be. So they're 100% focused on this song, not all the songs, not any of the things Drake said, this song. And that's where this battle is going to take place throughout the course of this document. And they're going to rebut a lot of the things that UMG said in their motion to dismiss. But they want this song being the only thing the judge considers when it comes to this motion to dismiss. That's why it's in quotes.
Tomato.
Now, obviously, it's good legal strategy, but rap battle in quotes is crazy. But UMG's theory collides with the reality that the recording's false allegations of PDF broadcast to the entire world via the most powerful music company have proven to be toxic and indelible. In other words, UMG's just joking narrative runs headfirst into the concrete facts alleged in the AC. Accepted as true, as they must be here, the amended complaint's allegations establish that Not Like Us was not widely understood to be mere hyperbole. Days after UMG published the recording and image, Drake's home was attacked and his security guard was nearly murdered. In the weeks that followed, countless listeners showed that they believed the allegations to be true, as confirmed by the commentators and press that covered the song. Now, on that shooting at the home thing, they're still saying that that is because of this song. Every document that we've read from Drake's team, from the pre-action petitions to this one, to the actual defamation lawsuit, continue to blame Drake's security guard getting shot because of they're putting the blame of that happening on this song. They're not including any conflict that might be there between OVO and the Weeknd's team. They're not referencing how the Weeknd's manager's home was shot up just a week prior. They're not mentioning how the Weeknd and Drake also have a long-standing conflict, and the Weeknd also was part of the Rap Avengers. He also was on We Don't Trust You, Future and Metro Boomin's album. None of that. They're still saying this song came out and Drake's house got shot up. So they're trying to make correlation causation. And so that is something that obviously, if this moves to discovery, if this gets to discovery and this case goes forward, we'll undoubtedly learn more about that. Because if I'm UMG, the first thing I'm saying is about that shooting with the shooting with the security guard, okay? Did you know, can I see your text messages, please? Because just a week prior, this other thing happened that also could be the reason why what took place at Drake's home, this horrible assault on his security guard, took place in the first place. Nor can UMG hide behind its hyperbole mantra, given its decision long after the rap battle, in quotes again, had ended and Drake had informed UMG of the substantial harm the recording had caused, to transform false accusations of PDF into a de facto national anthem by using its massive resources to land the recording as the centerpiece of the Super Bowl, the Grammys, and more, which is funny, right? Because I don't know if it's a national anthem, but it's become a number of nations' national anthems. I was just watching, was it a international Formula One race? Maybe it was a Formula One race that was taking place in Europe. So whoever won, they played Not Like Us. It's definitely at the DNC National Convention last year, but de facto national anthem. I'm not mad at that phrasing. 1 second applause. Unable to address the actual facts Drake has alleged, UMG instead asked this court to ignore them as unreliable and replace them with UMG's own disputed allegations offered through a 17-exhibit RJN. Though through these cherry-picked exhibits, which include news articles, podcast transcripts, and lyrics dating back years, UMG paints a self-serving picture of the context in which the recording was initially published, one that is irreconcilable with the context pleaded in the amended complaint. Now, they call that stuff cherry-picked here, but that's what that's what Drake's team did. Drake cherry-picked certain comments left on YouTube videos They cherry pick certain comments left on certain podcasters. They cherry pick certain things that seem to fall with the narrative that this was a defamatory piece of content that should be taken seriously. They didn't include any YouTube comments, for example, that post things like, yo, this is crazy, man. Like, clearly Drake's not a PDF, but this is a great song. They didn't pick any of those. So this cherry pick thing is a self-serving way to describe how they want to paint UMG's motion to dismiss.
Tomatoes.
Unsurprisingly, courts do not permit these kind of tactics at the motion to dismiss stage. Now, that's something that's going to come up quite a bit in this filing at the same time, right? So again, this document is purely to get the judge to not dismiss the case. And so part of their argument, a large part of their argument in here is going to be that, yeah, whatever UMG said, fine, but at this stage, a lot of the arguments that UMG made shouldn't even be taken into consideration because we're still at the motion to dismiss phase. Maybe if discovery happens, a lot of the things that we're accusing them of, or perhaps things even UMG is saying make this case irrelevant. Perhaps those things will come to light then, but that's what discovery is for. That's basically what Drake's team is saying. But even if the court were to accept UMG's disputed construction of the context, it's a rap battle. I know you guys are putting it in quotes, but it's actually a rap battle. It's a rap beef, really. But even if the court were to accept UMG's disputed construction of the context, there is no indication that the average listener watching the Super Bowl or browsing top hits on Spotify would have any knowledge of the nuances of a multi-year rap battle, let alone the subjective interpretation spun by UMG's lawyers here. Even if this court were inclined to agree that UMG's improper factual narrative, the motion to dismiss would still fail because the amended complaint pleads facts showing that the defamatory statements imply that they are based upon undisclosed facts, rendering them mixed opinion at most. In response, UMG argues, based again on extrinsic and disputed evidence, that listeners understood the recording to be referring merely to rumors concerning Drake's relationships with minors, which, like UMG's other arguments, cannot be squared with the amended complaint's actual allegations including that listeners understood the recording to be based upon actual and undisclosed information. Not only is this argument procedurally improper and unsupported by UMG's own exhibits, it also disproves UMG's main argument. Any listeners who were sufficiently clued in to understand that the recording was actually referencing prior questions raised about Drake's relationships with minors surely would have understood the lyrics as factual, not hyperbolic name calling. Well, we're going to get into the lyrics again, as we always do with these things. But, Drake said, tell him I like young girls. And so Kendrick did. Say, Drake, I heard you like young girls. I heard you like them young. That's what happened. But that's why Drake's team, again, is so focused on keeping this based on this one particular song and is putting rap battle in quotations so much. They're trying to convince this judge or convey to the judge that regardless of all this other broader context that's taking place, this is really about one song, and whether people who watch the Super Bowl, listen to, or watch the Grammys would have all this additional understanding of what it is. So that's one of the things they're going to keep alleging. The amended complaint also properly alleges a claim that Section 349 of the New York General Business Law. The amended complaint pleads how UMG secretly paid directly or indirectly streaming and radio platforms and others to boost the recording. UMG's failure to disclose these acts and practices deceived consumers of music in New York and harmed Drake both as an artist and consumer of music because the botting and artificial streams that UMG funded diluted and diminished Drake's royalties. UMG's arguments mostly seek to impose pleading requirements that do not exist, such as a requirement to plead actual knowledge, or that the deceptive acts and practices were the but for cause of the recording success. As for Drake's harassment claim, New York courts have long recognized that individuals may sue under Section 242.26 of the Penal Code. Drake sufficiently pleads that UMG intended to harass, annoy, or alarm Drake through its year-long publication and promotion of the defamatory material, especially after UMG knew about the violence and harm Drake was already experiencing. Well, that could be from other things Drake did. Drake be out here interacting with a lot of people. He pissed a lot of people off. Correlation is not causation. For all these reasons, the motion to dismiss and RJN should be denied. Now, here is, this footnote here talks about an amicus brief that was put together by a number of legal experts, longtime lawyers, who added an amicus brief. So an amicus brief is a piece of information that's submitted to the court, as I understand it, a piece of information that's submitted to the court by parties who are not actually going through the lawsuit. So it's not the plaintiff, it's not the defense. It's additional information that's really important that they want the judge to consider. And so a bunch of legal experts got together and they put an amicus brief together that said, hey, judge, I want you to know that what you're considering here, if this actually passes, would be super detrimental precedent to set when it comes to this form of artistic expression. These are rap battles that's been going on for 50 years, if not longer. This is something that's just a part of a broader culture that happens all the time. And if you chill, if you, by letting this case go forward, and in the event that Drake's team actually wins, they would chill the entire half a century old piece of artistic culture. And so at this footnote here, Drake's team addresses that. Listen to how snotty they sound. The amicus brief, ECF number 52-1, raises interesting academic issues. That's an interesting academic issue there. Oh, yeah, well, it's interesting academic. Raises interesting academic issues, but particularly at the pleading stage, offers no guidance for this court, right? So that's what I mentioned earlier when I said they're arguing again at this point in time. Certain types of things shouldn't even be considered anyway, right? Because they really want to get to discovery. They want to, clearly they're open to going to trial. Clearly they're trying to win. But the next main phase is to continue discovery, I guess, because the discovery was allowed in the previous round. It continues. It says, no authority supports the proposition that rap music can never defame a subject of that music, regardless of the actual words and imagery used in the music, the specific context of and around the song, or evidence of how listeners actually understood it. And in any event, this motion to dismiss is not the appropriate vehicle by which to announce such a sweeping legal policy. They're like, yeah, that's fine and all, but hey man, even though it's rap, it can still be defamatory. So technically everybody who's ever felt dissed or embarrassed to a certain degree, there's nothing in the in legal policy, in the Constitution, or in laws of various states or federal law that says you can't sue over this stuff. So basically, they don't care. They're saying it's an interesting academic issue, but for this, you got to throw it out, judge, because this makes no sense at this stage.
Tomato.
All right, so here's the background section. This is stuff that we say all the time. This is, UMG's colorization of how all of this happened, and none of it has to do with a rap battle. So we'll skip all this. We do this all the time. Now, standard of review, right? To survive a motion to dismiss under Federal Rule of Civil Procedure, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. On motion to dismiss, the court draws all reasonable inferences in the plaintiff's favor and accepts as true all non-conclusory allegations of fact. Because Rule 12b-6 motion challenges that the complaint as presented by the plaintiff taking no action of its basis in evidence, a court adjudicating such a motion may review only a narrow universe of materials, facts stated on the face of the complaint, documents appended to the complaint, or incorporated in the complaint by reference, and matters of which judicial notice may be taken. So I take that to mean they're reminding the court again, hey, you can only look at what we said. You can only look at this song. You can't look at all this other broader context at this particular stage. You have to just look at what's taking place on this song, and then whatever happens after that, happens after that. Let me know if I'm getting this wrong, if there's any legal experts in the audience, but that's how I read this particular piece. All right, so here's their argument. Now, they got four main arguments. Here's the first argument. The amended complaint adequately pleads defamation. A defamation plaintiff must plead, 1, a defamatory statement of fact, 2, that is false, 3, published to a third party, and 4, of and concerning the plaintiff, 5, made with applicable level of fault on the part of the speaker, 6, either causing special harm or constituting defamation per se, and 7, not protected by privilege. So it's so funny there. It's made with applicable level of fault on the part of the speaker. UMG is not the speaker, guys, just as a reminder. Kendrick's the speaker, and he's not getting sued. The motion to dismiss does not seriously dispute the sufficiency of the amended complaint as pleaded. Instead, it challenges only 2 elements: defamatory statement of fact and actual malice, based almost entirely upon materials extraneous to the amended complaint that, if relevant at all, should be introduced and tested through the adversarial process during discovery. So malice, see ASAP Logistics, UPS supply chain. Finding defendant conceded elements of claim when it failed to challenge elements on a motion to dismiss. A, the amended complaint adequately alleges that the defamatory statements are statements of fact. In determining whether allegedly defamatory material is fact or non-actionable opinion, the dispositive inquiry is whether a reasonable listener could have concluded that the statements were conveying facts about the plaintiff. Thus, while the question of whether the words could express the alleged defamatory meaning must be resolved by the court in the first instance, the actual meaning of those words must ultimately be determined at trial. So again, that's what they're saying. They're saying, yeah, cool, whatever, but this stuff we gotta hash this out at trial, which means we still need discovery, and it means we gotta go to court, because they don't want the case dismissed. Courts in this circuit analyze the Stein-Hilber factors to help distinguish between fact and opinion. So that's a previous court case that's coming up in previous documents as well. Those factors are whether the specific language in issue has a precise meaning which is readily understood, 2, whether the statements are capable of being proven true or false, and 3, whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. Motion to dismiss. Even a cursory review of the allegations in the amended complaint leaves no doubt that reasonable listeners could have concluded that the defamatory statements asserted factual allegations about Drake. Could have, right? So that's in bold and that's in italics if you're listening to this. Could have, right? They're not saying it absolutely did in this particular point. And so what they're saying is, if you just do like a light read of the amended complaint that we submitted, it leaves no doubt that reasonable listeners could have concluded. So they're patting themselves on the back. Indeed, unlike UMG's cases here, the amended complaint presents actual evidence that listeners, as well as commentators in the rap industry and the press, understood the defamatory statements as an attempt to convey a precise factual message, PDF, about Drake. Now, what they call this? They called this earlier, what they say? Cherry picked. They said UMG cherry picked. This is the stuff I was talking about. Well, this is Drake's team cherry picking. They didn't cherry pick all the commenters, it's particularly rap media commenters, who were very vocal about saying, no, I don't think Drake is a PDF. They didn't cherry pick Rob Markman saying that. They didn't cherry pick Joe Budden saying that. They didn't cherry pick Rory saying that. They didn't cherry pick a lot of things. They just went to the ones that they liked. So that's, it's a two-sided coin. That's just part of how the legal battle goes. At the pleading stage, these allegations are more than sufficient. For example, in Palin versus New York Times, the Second Circuit found that statements in a newspaper editorial were capable of being understood as statements of fact, in part because allegations of social media backlash further suggested that the Times readers perceived the false statements as fact-based. Now, what's interesting about Palin versus New York Times, that's Sarah Palin. And so she sued the New York Times for libel, I think it was. It was a libel lawsuit against the New York Times. She lost that case. The New York Times was found not guilty of libel in this particular situation. So the broader case isn't the best example, in my opinion, for Drake's team to be using, but they're using this particularly, again, because they're talking about at the pleading stage. And so that's where this is right now. So they're saying, well, they're not saying anything about what happened at the results of that court case. They're not saying anything like that, but they're saying, hey, this is a case that had to do with libel. And at the pleading stage, was allowed to go forward, and they used social media comments as well. So this is an example that supports our position. Similarly, in Fietosa versus Keem, the court denied defendant's motion to dismiss because reasonable readers could have understood a tweet accusing plaintiff of grooming underage girls to be an actionable statement of fact based on the complaint's allegations, citing social media posts communicating such belief. UMG's own authorities illustrate the same point in Belavia Blatt and Crossett versus Kell and Partners. After converting the motion to dismiss to a motion for summary judgment because defendant asked the court to consider extrinsic evidence, the court determined that an online comment constituted non-actionable opinion, in part because of the nature of the comments posted by other participants, which said things like, "I respect your opinion." Oh my God, this is crazy. That's such a crazy thing to be in the court. Not necessarily particularly in this case, but all of these people could be bots. All of them could be bots. It could be nothing but bots talking to bots. Have you seen the crazy stuff AI is doing these days? How fast AI works? This whole case has so many examples of how omnipotent botting is, how ubiquitous botting is in this space. And of course they say, oh, well, because of these comments, these other comments say, hey, I respect your opinion. All of them could be bots. This is so crazy. So crazy where we are in life. See Hazelwood versus Netflix, finding complaints inclusion of sample messages from individuals expressing concern and confusion over plaintiff's involvement in the film and his connection to the incident, relevant in deciding that complaint adequately alleged defamatory meaning. The motion to dismiss also fails to grapple with the reality that the recording, image, and video all work together to reinforce the unmistakable and false factual message that Drake is a PDF. Accusations of SA are especially dangerous because modern listeners are so susceptible to believing them. Now, I do agree with them on this point, right? We are in that era. You know, if you take, we saw this with Joey Badass, right? I mean, he rode in the car with Diddy and he was at his house and they were dancing, right? And because of what Diddy's on trial for now, a substantial number of people are equating him to freak-offs. Despite the fact that he's not named in any legal documents, despite the fact he hasn't been brought as a witness, despite the fact that he hasn't been coming up as a witness by any means, just because he was dancing with Diddy, two New Yorkers are dancing, hanging out, and riding in the car, that becomes a main thread in a rap battle, right? Become a primary thread, and the audience believes it. It's not even just that. Like what's that guy? What's that guy that Trump said he's going to give all the information about? Now they're like, oh, we're not giving the information anymore. Oh, actually, guys, we looked at it, and it turns out everything was actually true. What was it? Epstein. It's like post-Epstein world, post-Weinstein world. You know, the accusation itself, when it comes to the audience, modern listeners are very susceptible to believing him. You know, that's just kind of where we are in the era. And I do agree with them pointing this out. This is presumably why UMG and its chairman reacted so swiftly, including with threats of legal action when faced with similar accusations. Here, and unlike nearly every example UMG cites, including other songs within the battle, quote again, quote unquote, the recording is myopically focused on ensuring that listeners take one message away from the song. Drake is a PDF. False. Tomato, all that. See, this right here is that cherry pick. This is cherry picking. The recording is myopically focused on ensuring that listeners take one message away from the song. Drake is a PDF. Well, I took away that Drake is a colonizer. I took away that he called Future when he needed to see when he didn't see the club. I took away that Lil Baby helped get his lingo up. I took away that 21 gave him false street cred. I took away Thug made him feel like he's a slime in his head. I took away the fact that he's been eating off Atlanta. I also took away the fact that he smacked bellies with Lil Wayne's girlfriend while Wayne was in jail and got his name tatted like a bee apologizing. I took away a lot of stuff. A lot of stuff I took away from that song. It wasn't myopically focused on ensuring that listeners take one message away from the song, and that message is Drake is a PDF. No, that message is Drake is a terrible person who steals from other people and will have sex with your girlfriend while you're, if she's available and you're not. Also, Drake has a dicey crew of people that he keeps on the payroll. It's not myopic, it's not narrow, it's not one thing. But this is what they're trying to convince the court. Now, this is also a big, in my opinion, a big pivot from their original defamation filing. Because in the original defamation filing, and again in their amended complaint, they also said that the colonizer part was an attack on Drake's Jewish heritage. They said that they're essentially saying that calling Drake a colonizer is an anti-Semitic statement. They said that was in reference to Drake's Jewish heritage. So even by their own complaints that they filed, it's not myopic. By their false cherry-picked definition of what Kendrick meant by colonizer, hey, well, maybe Drake is also, their definition, their cherry-picked definition of that was that it was anti-Semitic to Drake and his heritage. So this right here is a pivot from themselves. This isn't even the same thing that they've previously argued.
Tomato.
For example, the line certified lover boys, certified PDFs, which is so self-evidently defamatory that the corporation responsible for the Super Bowl halftime show censored it, communicates that Drake has been found to be PDF, an assertion that UMG tacitly concedes Drake has adequately alleged at the pleading stage to be false. Now, they're also doing correlation and causation again right there. We don't know that they censored the word because it was defamatory. They censored the word. They might have censored the word because these guys are suey. These guys are in the middle of suing people, and they just don't want to deal with the headache. They just don't want to deal with the headache. So they're myopic. They're doing the same thing that they're accusing UMG of, which I guess is all part of legal arguments in the first place. But I can see through all this stuff. Having read everything that's come out around this, it's actually pretty funny watching them pivot and put more emphasis on things that they previously didn't when they made their initial filing, which was as broad as possible. And now I guess they're finding what's sticking or what's the stickiest, and they're doubling and tripling down on that. The same can be said for all the defamatory statements that, read in context, raise the same allegations, such as, you better not ever go to cell block 1, say Drake, I hear you like him young, trying to strike a chord in is probably A minor, and predators move in flocks. The amended complaint in detail how the associated image and video collectively reinforce that image. I mean, in their original complaint too, they had pictures of Kendrick hitting an owl piñata, and it said no OVHOs were harmed in the making of this video. So they use that as evidence of violence. It's so crazy. It's so crazy. And I don't find anything in the video. I don't think the video itself upholds their point in the way that I think they think it does. Now, perhaps the thumbnail I can see the thumbnail itself as being something the judge might look at and say, okay, well, this is enough to move forward. But the music video, it was heavily coded. And if you watch that music video, if they're talking about a reasonable person can't watch that music video and see obvious things that correlate to this song. Like that's one of the things that's so great about PG Lang and Kendrick and TDE. They're so layered in how their storytelling and their messaging. So I don't know. We'll see where this goes. Rather than challenging the sufficiency of what the amended complaint actually alleges, UMG's opinion argument attacks an imagined version of a complaint that Drake did not file and relies almost exclusively upon inappropriate uses of extraneous material. So this is what they're saying here is, again, like I mentioned before, they want all the focus on this song because obviously if you take the focus off this song and broaden the scope, then actually Drake looks terrible. He looks terrible. and it goes against their entire argument. And that's what this line says. Rather than challenging the sufficiency of what the amended complaint actually alleges, UMG's opinion argument attacks an imagined version of a complaint that Drake did not file. Exactly. Drake did not talk about all the lies he told about, or how about this? Drake did not talk about how, Drake's team did not talk about how on Family Matters, they make wild allegations, I'd argue defamatory statements against Kendrick Lamar, but particularly Whitney. Drake's team did not include Tailor-Made Freestyle, where they said, hey, Kendrick, why don't you tell them that I like young girls, when he told Kendrick to do that. They didn't include, the threats of violence that Drake had on the Heart Part 6. All of that makes their case, in my opinion, and I'd argue to a reasonable listener, fall apart. And here they're urging the court to say, yo, we didn't even file that. That's not what we filed. They went and added other information. They shouldn't even add other information. And you know what? It's inappropriate. It's actually inappropriate for them to use extraneous materials in this way. So
Tomato.
That's basically what they're saying. First, UMG tries to brush aside the public commentary expressing belief in the defamatory statements, claiming that the subjective opinions of a handful of people do not factor into the court's objective assessment of what a reasonable person could have understood the recording to mean. But the amended complaint plausibly alleges that millions of people, not a handful of people, understood the lyrics as factual, and at this stage, the court must make all reasonable inferences in Drake's favor, not UMG's. I don't know, look at the sentence, but the amended complaint plausibly alleges that millions of people, I didn't see that. Now, they know their document better than I did, but it looked like they cherry-picked people in comment sections on Twitter and select podcasters that what they said. There's no, for example, they didn't include a Google analysis, right? They didn't do a Google Trends chart that shows Drake PDF when it spikes. They didn't have that as an exhibit. They just said it based off of what they cherry picked. So, I mean, this whole thing is so infuriating to me.
Tomato.
In any event, UMG cites no authority suggesting the court cannot consider at the pleading stage real-life examples of listeners believing the truth of the defamatory statements in evaluating whether the statements could have been interpreted as fact. As illustrated above, courts have done exactly that. So here's some examples. UMG cites Rappaport versus Barstool Sports. Now, we talked about this. We even played the diss track that Barstool made at Michael Rappaport. And so UMG is using that as an example of a contentious argument between Barstool Sports and Michael Rappaport, where Barstool Sports made a diss track song and a video that Michael Rappaport felt was defamatory and sued them over that. And UMG used that example in order to show precedent that, when you have a beef with two people and someone makes a rap song, well, the reasonable listener understands that it's not true. And here's a court example where that was found to be the case. UMG spends a lot of time in here attacking that particular case, right? That particular case. And here's the first moment where they do. Here's what they say. UMG cites Rappaport versus Barstool Sports, where after losing summary judgment, plaintiff argued on appeal that the district court overlooked evidence relating to the public comments accusing plaintiff of misconduct raised in allegedly defamatory material. The Second Circuit denied the appeal, but without referencing or discussing this particular argument in any way whatsoever. Moreover, the public comments cited by the plaintiff in Rappaport are far less compelling than those alleged here. Compare example Q with paragraphs 72 through 89. And the plaintiff in Rappaport did not even argue on summary judgment that the allegedly defamatory material was factual based on the online comments, meaning the district court had no opportunity to consider plaintiff's theory. So what they're saying is, yeah, that's what this case was about, that the similarities between Rappaport and this case stop at the fact that it was a defamation case in the rap video. What they're saying is the things that Drake's team is arguing in this case weren't even applied, and in some senses were overlooked and weren't even considered. So I guess by proxy, What they're saying is, if those things have been considered, then it'd be more apples to apples. But since they weren't, this is more apples and oranges. This isn't the first time Rappaport's going to come up either. UMG likewise deems the public commentary cited in the amended complaint unreliable because it comes with anonymous users and contains grammatical errors, slangs, and emojis. Americans can't read.
Tomato.
But the amended complaint does not solely rely on anonymous social media users. Instead, it cites numerous public statements expressing belief in the allegations from the press, commentators, and podcasts. Cherry-picked. They should just go get Rob Markman. But they can't, because Rob Markman's been running around saying Drake's not a PDF. And that doesn't fit the argument that they're making. They can get a number of people, most people, in fact. I'd argue most commentators in the space have been saying most accredited, respected voices of influence in this space have been saying Drake's not a PDF. I'd argue that. UMG's own extraneous exhibits are in accord. Trade press throughout Not Like Us, Kendrick accuses Drake of having inappropriate relationships with minors. Footnote 6, discovery, not this motion, is the appropriate time to consider UMG's arguments about what the relevant context shows about the public's understanding of the defamatory material. Exactly, and I mentioned that earlier. This, again, is to get the court to deny the motion to dismiss. And it's using these examples to say, well, we'll just go through discovery. We'll go through discovery and we'll see if this is true. They fishing. Many of the amended complaints cited social media comments were not anonymous. And using slang and emojis in online posts and pop culture is hardly unusual. Regardless, UMG again offers no authority for the proposition that the court should discredit the amended complaint cited online comments in this context, and case law is to the contrary. So footnote 7, Solid FX versus Jefferson Sanderson is irrelevant because it concerns a motion in Le Mine to exclude anonymous online reviews. Back to the filing, CEG Fiat Tosa, relying on Twitter posts from users with handles such as Memelin. So they're citing another case where Twitter comments were used as evidence. Second, UMG argues the tone of the defamatory material conveys hyperbole and opinion, not facts. That subjective assessment is belied by the countless listeners who think otherwise, but in any event, there is nothing hyperbolic about using mutually reinforcing lyrics, images, and video to brand someone as a certified PDF. Moreover, the fact that allegations of PDF can be understood to express anger or vitriol does not mean that no reasonable listener interprets those same allegations as factual. To the contrary, the amended complaint alleges that allegations of PDF tap into a cultural phenomenon whereby listeners are primed simultaneously to believe and be enraged by such allegations. The defamatory material is also unlike the types of communications courts have dismissed as non-actionable opinion. Union recording, broadcast only to union members, was full of nonsensical and juvenile humor, such as, in Barbara's case, brains aren't everything. In her case, they are nothing. And in times of trouble, she is waiting to catch you bent over at the right angle. So they're referencing Stein-Hilber versus Alphonse. This is another case that UMG referenced in their legal filings. That's crazy. In times of trouble, she's waiting to catch you bent over at the right angle. Brian V. Richardson is another case that said op-ed was rife with humor, speculation, and seemingly tenuous inferences, relied on unnamed sources, and informants and accusations were identified as claims where the author set out the basis for his personal opinion. Hayashi versus Ozawa, heated statements in personal blog posts, non-actionable because they went back and forth as to whether it is criminal or fraudulent for plaintiff to refer to herself as a doctor. Statements were caveated with qualifying language such as it can be considered fraud, and accusations of perjury were absurd because statements had nothing to do with perjury. And in Sandals Resorts versus Google, tone of anonymous email was rhetorical and laden with rhetorical questions. Email constituted pure opinion because each remark was prompted by or responsive to a hyperlink containing source material. Belavia, online comment attacking law firm was rhetorical opinion because it was full of qualifiers. Here, the defamatory material does not cite sources, identify allegations as claims, oscillate back and forth as to whether Drake is a PDF, or express rhetorical questions with qualifiers. Pointedly, none of UMG's cases involved allegations of PDF, and none involved specific factual allegations demonstrating the public's belief in the truth of these allegations. And I'd argue that their amended complaint didn't really do a great job of that either. I'd argue that because they only took one side of the conversations. Now, I guess what they're saying is in UMG's rebuttal, they didn't find those particular comments and find some of the comments that might have been left under the comments. I guess that's how they would have to look at that on the other side, right? So UMG, I guess, had the opportunity to just go find those exact posts. Well, they did do that, though. They did point out, a couple of tweets that weren't even up anymore that had been deleted, so I don't know. I guess this will be just another situation that the judge has an option to see either way. UMG relies heavily on the Rappaport summary judgment decision to support its flawed tone argument, motion to dismiss 1016, but separate from the fact that Rappaport does not justify dismissal at the pleading stage, the case is readily distinguishable, right? So here's Rappaport again, right? So they're using Rappaport. They're saying that argument's flawed. They already pointed out different aspects of that case that were not relevant to Rappaport that are included here. And they're going back again on top of it and say, either way, none of that justifies dismissal at the pleading stage, which is where we are now. The case is readily distinguishable. There, the statements that the court found to be obviously hyperbolic included the plaintiff was a 10-gallon drum of curdled milk, a walking blob of jizz, and a puddle of pudding, and that he looks like a chemo Yertle, the turtle, Rappaport versus Barstool. But being repeatedly accused of PDF to billions of people is obviously different from being compared to a Dr. Seuss character or spoiled dairy. The former is a precise factual allegation that people immediately understand. The latter is literal name calling. Now, the other part of Rappaport that was significant and, in my opinion, parallel to what this case is, when they started talking about him having herpes or giving people herpes, right? I think that would be something that's closer to PDF allegations than, the name calling over here, right? And that's the same thing with, that's truthfully the same thing with what I think about Not Like Us, because in UMG's original filing, they had wop, 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 wop as a threat. As a threat. They listed wop, wop, wop. I think it's in the amended complaint too. They listed wop, 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 wop as a threat of violence. So they're taking their own liberties here as well. Back to the filing. The same argument holds with respect to the images in Rappaport. The Rappaport court determined that certain photos, including the cartoon of a life-size cracker walking down the sidewalk, accompanied by the terms, "You're the cracker, honky." That's so funny. Because it's in all caps, too. One second applause. To all caps. Were obviously doctored and therefore underscored the non-factual nature of the piece. The court found the same for a cartoon in which the plaintiff was diagnosed with having ding-dong for brains and had a herpes that worked as his manager. So here's the images that they're talking about. So this is Not Like Us. And they're saying this isn't as obvious as this one, right? So I think reasonably, sure, right? Definitely. But this is so easily verifiable. like you could just look up the address and go see if these things are there. You know what I mean? So nevertheless, unlike an anthropomorphized cracker sauntering down the street, the image that appears alongside the recording is an authentic aerial photograph of Drake's Toronto home, and the S-offender images attached to the homes are likewise realistic reproductions of images commonly understood to signify the homes of registered S-offenders, which is why the average observer understood the image as conveying a false message that Drake is an S-offender. UMG's insistence that the image is doctored in the sense that it is superimposed as S-offender symbols on Drake's actual home only confesses the falsity of the message conveyed, and UMG has cited nothing, particularly in the pleading stage, to justify a subjective view that no reasonable observer would have interpreted the image's inescapable message as factual. Third, UMG asserts with no support from the pleadings that a rap diss track is not a forum reasonable people expect to convey rigorous factual content. Whatever weight UMG's argument might receive following cross-examination of whatever witness might offer it at trial, it should receive none here. The amended complaint that UMG's standard exclusive recording contract includes a provision which permits UMG to eliminate material which, in UMG's judgment, constitutes defamation or libel. The necessary inference from that fact, which must be drawn in Drake's favor, is that UMG itself understands that lyrics and other content within the music it publishes can defame. Moreover, UMG's context argument relies almost entirely on cherry-picked extrinsic evidence, such as lyrics and articles not referenced in the amended complaint, that UMG repackages and weaves into its own subjective narrative. But UMG offers no authority for substituting well-pleaded allegations with extraneous evidence on a motion to dismiss. In Fiat Sosa, the court denied the defendant's request for judicial notice on similar facts. In response to a complaint alleging a defamatory tweet by a YouTube personality made during a war of words between the two influencers, the defendant's motion to dismiss submitted in his own selection of tweets, including from the plaintiff, add a link to a podcast interview to support his version of the context this court should consider. The court held defendant submissions are far broader than what courts normally consider in assessing a statement's context, let alone what courts consider on a motion to dismiss. The court therefore declined to consider the documents defendant submits and will consider the face of the complaint. The same results should follow here. Specifically, the court should decline to take judicial notice of UMG exhibits A through I and LN, or at the very least consider only the existence of those exhibits and decline to consider UMG's factual inferences based on the content of those exhibits. O'Keefe versus Ogilvy. UMG's footnote 8. Insofar as UMG offers other exhibits to support its own version of the context, such as exhibits J, K, O, P, the court should not give any weight to UMG's assertions. UMG's alternative would require the court to wade through an entire bodies of literature, effectively fashioning its own expert testimony, addressing the appropriate context for understanding the lyrics of not just Drake and Kendrick Lamar, but of other rap artists, rap tracks, and articles omitted from UMG's self-serving collection. None of this is remotely appropriate given the court's task to determine whether the amended complaint states a claim upon which relief may be granted under 12b-6. Footnote 9. UMG's authorities are in accord. See Boblinski versus Tarlov, where alleged defamatory comments concerned a hearing before House Oversight Committee, and the complaint quoted from the hearing takes judicial notice of the hearing transcript. Taking judicial notice of news articles for purposes of deciding whether storm warnings were adequate to trigger inquiry notice for statute of limitations. To the extent the court assesses context at this stage, UMG has done nothing to justify its assertion that the relevant context for all reasonable listeners would be its hand-selected examples from what it describes as a years-long rap battle involving multiple tracks from Drake and Kendrick Lamar. Nowhere does UMG explain why the average or reasonable listener would not only understand all of the nuances of this saga, but also understand it in the same way that UMG's lawyers do. As alleged, the recordings has been played billions of times to people globally, including the audience and viewers of the Super Bowl and Democratic National Convention. There's a DNC reference. Finally, they got that reference in there. 1 second applause, even though you're late. Thus, as alleged in the AC, the relevant reasonable listener cannot be artificially limited to the devoted fans of Kendrick Lamar's music or those who carefully followed each step of the battle. Rejecting C. Lindell versus Mail Media, rejecting argument that relevant audience for the purpose of evaluating defamatory meaning was limited to the public familiar with the plaintiff's life and nonprofit rather than entire public that saw the at-issue statements. Also see Stein-Hilber. Private union recording was non-actionable when played only to members of the union who would have understood it was prepared and played as part of the union's effort to punish the plaintiff. UMG utterly ignores the amended complaint's well-pleaded allegations that UMG took steps to ensure that the defamatory material became ubiquitous in the general population, while not doing so for any of the other songs in the rap beef. Thus, by its own actions, UMG ensured that the relevant audience for the recording would be different and much more expansive than the traditional audience for a typical track. Now, to me, that goes against how record labels work. One, you're talking about UMG, sure, but you're also talking about Interscope on one side and Republic on the other side, too. Once a track raises its hand, usually that's when a lot of investment will follow a song, as opposed to prior to the internet age or streaming age, for example, prior to streaming, rather. A lot of times, the team would get together, pick the track they wanted to push, and then they go ahead and put money behind it, and they go see how it performs in the marketplace. If it really does well, they put more money behind it. We're in an age now where a lot of times, there might be a lead song or something that people put out first, but if a song raises its hand, then you throw money at it. Oh my God, you see what this one's streaming right here? Let's throw some money at it. You know what I mean? Like that's really where we are. And it's been like that for a long time from just sort of how supply chain standpoint in the music industry for a very long time, at least a decade, right? And so what that's leaving out, like this argument is leaving that part out. And so with that understanding, Family Matters didn't raise his hand. Taylor Made Freestyle wasn't even, that's not even a legal song to release. Hard Part 6, Drake took down on his own. And then you have Push-Ups, which I'd argue probably did the best, but also he put out 2 different versions of that song at one point in time, right? Point is, those songs didn't raise their hand in the way that Not Like Us did. Euphoria raised his hand too, but they came out the same week. So they went and pushed Not Like Us because it has more crossover appeal for whatever reasons that they came up with. But none of what UMG is saying right here, they're putting it on UMG's actions as being some sort of correlation that equals causation. Thus, by its own actions, UMG ensured that the relevant audience for the recording would be different and much more expansive than the traditional audience for a typical rap track. No, what they did, from my point of view, is, this song is moving. Let's put money into it. That's what that looks like to me. Furthermore, UMG's context argument ignores that most of the alleged complaints, allegations of actual defamation occurred after, according to UMG, the rap battle ended. UMG published and promoted the defamatory material long after it knew how the public was consuming and reacting to the material, which makes this case unlike heated or one-time statements made during a union, labor dispute, a public meeting, or a shock talk host during a show. UMG's repeated conduct, including licensing deals, social media posts, and agreements to stream and play the recording, are more like pre-planned and pre-scheduled statements made during a sophisticated and coordinated international campaign, which courts have found to be actionable. Courts have rejected arguments in similar circumstances. In Fiat Sosa, the court found actionable a tweet by one YouTube personality directed at another, which stated, "Def Noodles has allegedly groomed girls from ages 12 to 15, even though it was made during a war of words between 2 internet personalities." In Delgado versus Sonnen, the court held that the statements that the plaintiff was a stalker made during an intentionally comedic podcast published to the internet were actionable. The court explained that the context relevant to its analysis did not include all previous episodes of the podcast or even the entire podcast episode, but rather the specific podcast segment which the at-issue statements were made. Even assuming the entire podcast series constituted the relevant context, the statements would still be actionable because the court reasoned the defendant could not expect to be protected solely because it's in the internet publication with a foolhardy reputation that was known for loose, irreverent, juvenile, and crass behavior. I mean, that's That is a terrible, to me, that's a terrible precedent. Not for this case. I think obviously, this is a supportive argument for Drake's team's bigger mission, which is to get the judge to deny this motion to dismiss. But like, if someone sues the Onion, and maybe this happened, I don't know the Onion's legal history, but if someone posted something in the Onion or the Onion published something that really pissed someone off and they sued over it, and the precedent was this precedent that's used here, Def Noodle's precedent that they're mentioning, or Delgado versus Sonnen. According to that, the fact that the Onion is the Onion, straight 100% satirical publication, with that understanding, the Onion could be legally liable or legally at risk based on whatever they just said to get Delgado and Sonnen, that court decided. I don't know. I mean, I think one thing I look at is like, just because there's a precedent to something doesn't mean that it's a good precedent. So I don't know. There's probably thousands of defamation cases that have taken place in the history of American case law. So you could probably pick and choose whatever you need to help try to convince the judge. Ultimately, it's up to the judge's point of view where this goes. But here's the footnotes I missed. UMG's other context cases are similarly inopposite. See Immuno AG versus Moore-Janowski. Letter to the editor in the scientific journal was qualified by prefatory editorial notes, signaling that the letter was to be given only weight its readers chose to accord. Addressing statements made on Yelp, which is specifically used by consumers to provide their positive or negative opinions of business. They be botted too over there at Yelp. All right, so B, it gets a lot shorter here, so we're almost done. Well, close enough to being almost done. There we go. The amended complaint adequately alleges that the defamatory statements are mixed opinion. Dismissal is likewise unwarranted because a statement of opinion is actionable so long as it implies that it is based upon facts which justify the opinion but are unknown to those reading or hearing it. The amended complaint alleges just that. Here, the defamatory material and pleaded context imply that the allegations of PDF against Drake in the defamatory statements have a factual basis that is not disclosed in the recording itself. In the recording, Kendrick Lamar says that the allegations are based on undisclosed information. Say Drake, I hear you like him young, and rabbit hole is deep, I can go further, I promise. Well, say Drake, I hear you like him young isn't undisclosed information. That is what Drake said Kendrick should say. And that, to me, right here is an example of their circular logic or their contradictory presentation of the facts, right? They're sitting here saying, we can only look at this song, right? But they are misrepresenting this song or misunderstanding this song by calling that Say Drake, I Hear You Like Him Young line. In the recording, Kendrick Lamar says that the allegations are based on undisclosed information. It's not undisclosed. That line was disclosed by Drake. That particular line was definitely disclosed by Drake. Drake said, go ahead and tell him you like young girls as a gift from me. Heard it on the Budded podcast, it's gotta be true, right? He said that. He wrote that, he recorded that, he put that out. Or he wrote that, he used AI to kick out Tupac's voice saying it. But he said that, and that's not undisclosed. That's very much disclosed. But they're making the argument that the court can't even consider that because they can only focus on this song. And since they can only focus on this song, they're saying it's not disclosed. I guess the argument would be it's not disclosed in this song. But that's a manipulation of the environment. That's why they keep putting battle rap and rap battle in quotes.
Tomato.
And rabbit hole is still deep, I can go further, I promise. The amended complaint alleges concrete examples of listeners who understood the recording in these precise terms, notwithstanding UMG's claim that the statements were too vague and sound in hyperbole. UMG suggests that the defamatory statements were not mixed opinion because Drake previously goaded Lamar. However, this argument depends entirely on UMG's self-serving and disputed interpretation of the meaning of one of Drake's songs that is not referenced in the amended complaint and is therefore improper at the pleading stage. Roth versus Jennings, that was another court case that UMG referenced. Even if this court were inclined to consider this evidence without the vital witness testimony that would inform it at trial as a legal matter, consent for defamation requires far more than a plaintiff expressing an expectation that another party will make a defamatory statement or even encouraging a defendant to do what they had to do. And of course, none of this would erase UMG's liability for continuing its relentless promotional campaign after Drake explained to UMG the harm he was suffering and made his retraction demand. In sum, there are no allegations that Drake consented to or invited UMG to publish defamatory statements about him to millions of people over the course of the year, except for the fact that Drake did it too. Sometimes someone's actions tell you what they're okay with. And Drake's actions, Drake jumped out the window first with the defamatory statements. But Drake's team is running away from that because they want this to be solely based on this song. And they have to base it on this song because Drake's action on push-ups, on tailor-made freestyle, on Family Matters, I'd argue those are the ones that invited this quote-unquote defamatory statements. That's what invited it. I'd argue that. But let me know if I'm misreading that, if you're a legal expert in the audience. Finally, UMG argues that the defamatory statements are non-actionable because facts and circumstances concerning Drake's relationship with minors have been widely reported, and therefore the defamatory statements relate to controversies that are widely known. Motion to dismiss 1718. Footnote 11. So that says, as noted supra, the court should decline to take judicial notice of Exhibit B. This argument says more about UMG than it does about any legal issue in this case. For starters, as alleged in the amended complaint, UMG does not truly believe that there were serious questions concerning Drake's relationships with minors predating his publication of the recording. Because if it did, UMG surely would have discontinued promoting Drake as one of his most prominent artists. Even taking UMG at its word, its cited exhibits do not come close to demonstrating that Drake was widely reported or reported at all as having engaged in conduct that would make him a PDF or a registered S offender. Namely, UMG cites no reporting, let alone widespread reporting, that Drake engaged in S relationships with minors, such that any reasonable listener would have understood the defamatory statements to be based upon those non-existent reports. Compare E.G., Jizzle, Clear Channel, etc. Finding on summary judgment motion that radio show host statements were non-actionable opinion because they were based on facts that were widely reported by Western New York media outlets and were known to his listeners. And then another case where it's finding it impossible that an informed listener would think that statement made during a press conference describing plaintiff radio DJ as a sick PDF loser was based on some undisclosed information known to only to defendant when plaintiff had recently made public comments widely reported in the media that he wanted to are the child of a rival disc jockey, and so clearly the impugnant statement was based on those reports, not undisclosed facts. If anything, UMG's exhibits reinforce that commentators understood the recording as making allegations against Drake, not merely reporting prior rumors. I don't know. I mean, they reported, whatchamacallit? What's her name? What's her name? 12, 11? What's her name? 11? What's homegirl's name? Oh my gosh. From that show, Stranger Things. What's her name? I can't remember her name. But she was in the documents, and they talked about what she said, about how Drake would text her and talk about boys. And that was one of the footnotes that was in there. So they did do that, at least. I don't know if there's ever been a time where two rap superstars are contemporaries, and one is accusing the other of PDF, like in the loudest way possible. And we all know the stories of him going to girls' basketball games. But contemporaries, people who are making their record label millions of dollars, right? That doesn't usually happen. So this level of allegation, maybe it should inspire some sort of investigation. Emphasis added. 12, the discovery is the appropriate mechanism by which to test UMG's argument about what the context shows about the public's understanding of the defamatory material. For the purposes of the motion to dismiss, it is more than enough that the amended complaints allegations contradict UMG's characterization of the public understanding. So here they go again, right? So what they're saying again is what we were talking about in the beginning. Yeah, either way, we got to go through discovery to really see what this stuff is. And so that's really the position that this document is taking more than any other. All right, we're wrapping up. C, the amended complaint adequately alleges actual malice. UMG addresses actual malice in a single paragraph that merely repackages its opinion and hyperbole arguments. Its argument is meritless. The actual malice standard requires that the plaintiff show the defendant made the statements at issue with knowledge that the statements were false or with reckless disregard as to their falsity. At the pleadings, malice must be alleged plausibly in accordance with Rule 8. Therefore, plaintiff must plead plausible grounds to infer actual malice by alleging enough facts to raise a reasonable expectation that discovery will reveal evidence of actual malice. The motion to dismiss does not dispute that the amended complaint pleads actual malice under these standards. UMG does not contest that it knew the allegations were false, and to this day, UMG does not claim that any of the allegations are true. UMG had financial interest in knowing Drake's liabilities, including charges or convictions, and UMG would have never contracted with Drake had it believed that any of the defamatory material were true in any respect. The amended complaint further pleads actual malice based on the different points in time when UMG published and continued to publish the defamatory statements, including after Drake publicly denied the allegations one day after the initial publication, after Drake's security guard was shot 3 days after the initial publication. They keep putting it on this. They keep putting that on this. I don't believe that's the case. After listeners, music publications, and industry podcasts confirmed the public's understanding of the factual nature of the allegations, and after Drake issued a formal retraction demand detailing the harm caused by the recording's continuous publication 3 months after the initial publication, right? And so this third one, after listeners, music publications, and industry podcasts confirm the public's understanding of the factual nature of the allegations. That's a cherry pick statement too, right? That's actually still a debate. You know, there's just as many, at this point in time, just as many people believe the opposite as, you know, people who might take these things to be actually true. UMG argues that plaintiff must identify specific individuals that UMG had at UMG that acted with actual malice. UMG cites no Second Circuit authority for this proposition. It relies on Hughes versus 21st Century Fox, but that case cites to a summary judgment holding Donguk, and I guess that's the name, and a post-trial holding Sullivan. The Second Circuit in Palin merely observed that the critical question in the state of mind of those responsible for the publication, it did not create a separate pleading standard when the defendant is a corporation. This makes sense because discovery is essential to permit plaintiff to confirm which individuals at UMG were responsible for A, greenlighting the recording notwithstanding its lyrics, B, greenlighting the image and video notwithstanding the offensive imagery, and C, deciding to continue to promote the recording notwithstanding the known harm it was causing to Drake. In any event, the amended complaint adequately pleads plausible grounds to infer the requisite mental state of each of Lucien Grange, UMG CEO, John Janik, Interscope CEO, Monty Littman, Republic CEO, and Avery Littman, Republic President. So Republic, Avery and Monty are Drake CEOs. John Janik is the Interscope CEO, and then Lucien Grange. Now, I'd be shocked if Lucien Grange was sitting around saying, oh, we about to put that out? Fire. Let's go ahead and do it. Push the button. He's so far away from the action of these two sub-companies, I can't imagine that. They want to require, they want to plead plausible grounds to infer the requisite mental state of Lucien Grange. It's so crazy to me. Now, I guess that ties into their broader argument, which is, They're arguing that UMG had motivations to decrease Drake's value by letting him be called a PDF so they can sign him for cheap so they can sell a PDF? I don't know, man. That's crazy to me. Because the other parts of this document are arguing straight up and down that if Drake was a PDF, they wouldn't put his music out. They would have never, that's the past 4 pages we just read, that's what that's saying. If Drake was a PDF, they would never put this music out. But their broader argument is that they are motivated to devalue Drake so they can sign him for cheaper. UMG's been arguing that at every stage, every step of the way. They've been arguing against that every step of the way, right? Every step of the way they've been saying that makes no sense to us. And now they're saying we need to And now they're over here saying, well, we need to look at the mental state of these guys when they publish this. And they're saying that if Drake was really these things, they wouldn't sign him. But now they wanted to make him look like these things so they can sign him for cheaper. It doesn't work. I mean, circular logic doesn't keep up for me. The amended complaint further pleads that Sir Grange, Mr. Janik, Monty Littman, and Avery Littman played a key role in the initial publication of the video, either in directing or approving the publication and or failing to prevent its publication. That's what and so the failing to prevent its publication, that's where they're pointing fingers at Monty and Avery Littman. They're saying, these guys didn't stop it. They didn't talk to Interscope and say, we got to keep this video from being published. I'm not even sure what the communication is like between these two completely different verticals. But also in initial filing, they talked about how Monty Littman, Avery Littman, or I think Monty Littman and John Janik are competing right now to be the next CEO of UMG, so to take Lucian Grange's job when he steps down, right? So they're competing to do that right now. So their initial defamation case was basically saying Monty and Avery didn't stop it so that they could move up in the company. Oh, no, man. It's all over the place when you get to this part. Mr. Janik, okay, so the amended complaint further pleads that Sir Grange, Mr. Janik, Monty Littman, and Avery Littman played a key role in the initial publication of the video, either in directing or approving the publication and or failing to prevent its publication, knowing that Drake's Toronto home was attacked, knowing that the allegations were unsupported by any evidence, and were being believed by the public, and despite the inherent improbability of the allegations. They keep doing that thing with his house. Like, part of me wants this to go to discovery so I could have peace of mind in my mind. I'm so curious now. I'd love to see those text messages because they keep saying his home was attacked. They keep saying the security guard thing. And they're saying this because of this song. And I just don't believe that to be true. These allegations, combined with other well-pleaded allegations demonstrating that UMG knew the defamatory statements were false, plead plausible grounds to infer actual malice on the part of UMG. 2, the amended complaint accurately pleads a claim under New York general business law. So this part actually looks at the botting stuff. And so here's what it says. In order to plead a violation of New York general business law, section 349, plaintiff must allege that the defendant engaged in 1, consumer-oriented conduct that is materially, 2, materially misleading, and that 3, the plaintiff suffered injury as a result of the alleged deceptive act or practice. UMG does not dispute the first element. The amended complaint alleges that UMG's scheme to promote the recording and video was directed at consumers of music. With respect to the second element, conduct is materially misleading when it's likely to mislead a reasonable consumer acting reasonably under those circumstances. This is generally a question of a fact not suited for resolution at the motion to dismiss stage. There that is again. They're just trying to say, hey, we got to let this go forward. So you're seeing the consistency in which they're saying that. Here, the amended complaint alleges that UMG financially incentivized third parties, including streaming platforms and radio stations, to recommend, prioritize in searches, promote as top-rated or most popular, and ultimately play the recording, all without disclosing its conduct. These deceptive acts and practices, at the very least, raise a prospect that reasonable music consumers would be misled in a material way. That is because reasonable music consumers do not assume the recommended song search results and promoted playlists are the results of the artist label funneling payments or consideration to the platform through a series of clandestine back-channel payments. I'd argue that. I think everybody knows America's for sale. Everything in America is for sale. I mean, we have this idea that, yeah, you know, the cream rises to the top, everything is fair and balanced, but I think the general person knows that whoever got the most money gets the most access. Indeed, when the New York Attorney General previously charged UMG with payola violations, he explained consumers have a right to not be misled about the way in which the music they hear on the radio is selected. Put simply, Section 349 seeks to secure an honest marketplace where trust and not deception prevails. UMG criticizes plaintiff for pleading on information and belief without a statement of facts upon which the belief is founded. Right, I was critical of that too, because all they said was on information and belief. That's their version of on information and belief. And for this lawsuit and the documents that have been going back and forth, when UMG says on information and belief, That's like what they're accusing Kendrick of saying when he says, the rabbit hole's deep, I can go further, I promise. That's what's so ironic about this. They're like, on information and belief, on information and belief, on information and belief. I'm not providing the information. I'm not telling you why I believe that, but on information and belief. And then in the same document, they're in here saying, but when Kendrick says the rabbit hole's deep, I can go further, I promise. That's totally different. So anytime you hear information and belief in here, it's the same thing as what they're accusing of Kendrick of meaning when they said, the rabbit hole's deep, I can go further, I promise. 1 second applause to Kendrick Lamar. That is not the rule. Twombly's plausibility standard does not prevent a plaintiff from pleading facts alleged upon information and belief where the facts are peculiarly within the possession of the control of the defendant or where the belief is based on factual information that makes the inference of culpability plausible. So basically what they're saying is, well, we can only say information and belief because the defendant has all the facts, right? So UMG has all the information. We need to go through discovery to get it. So it's okay for us to use information and belief. It's okay for us to say the rabbit hole is deep. I can go further, I promise. Both conditions are satisfied here. The amended complaint pleads that UMG concealed its promotional scheme by making indirect payments through a network of unknown third parties, permitting information and belief pleading where the defendant's precise role in the alleged scheme perpetrated by the web of interrelated defendants, LLCs, would be facts peculiarly within the possession and control of the defendants. The amended complaint also pleads sufficient factual information concerning UMG's scheme, including examples thereof, contemporary reports, as well as UMG's past practices. UMG then argues that plaintiff fails to plausibly allege that UMG had actual knowledge of any conduct or accusations concerning Lamar, citing a case analyzing common law fraud, but there is no requirement under Section 349 that plaintiff pled actual knowledge of anything on the part of UMG. Even if there were, the amended complaint alleges that UMG had actual knowledge of its own deceptive practices or acts. Next, UMG attempts to challenge materiality, arguing that Drake does not and cannot allege that Not Like Us would not have been an immense success had it not been for alleged financial incentives at issue. That is a non sequitur. All right, so number 13, footnote 13 says, nor is there any requirement that plaintiff plead specific transactions that cause cognizable harm to consumers in New York. The phrase commercial transaction can be found nowhere in the plain language of the statute, and Section 349H specifically empowers any person who has been injured by reason of any violation of this section to bring an action. In Merrill Tertiary, UMG cites Goshen versus Mutt Life, but that case analyzed the question of where consumer deception must occur, holding that the transaction in which the consumer is deceived must occur in New York. Here, the amended complaint alleges that UMG's failure to disclose payments to streaming platforms and radio stations harm music consumers in New York by inferring with their ability to evaluate their market options and to make a free and intelligent choice. Plaintiff need not allege pecuniary harm to consumers in New York. So pecuniary means financial harm. All right. With respect to the third element, the amended complaint alleges that UMG's promotional scheme and failure to disclose the same injured Drake. As an artist, Drake suffered pecuniary harm. Artificial streams decreased the unit value of a stream and therefore decreased the amount of royalties paid to rights holders, including Drake. They could just use they could use Drake's own contracts to prove this stuff. Like, they have the data around this. They don't need discovery to do this. They can use Drake as the example. They can use his contracts. They can use his history on streaming. They can use his information and correspondence that he has, his team has, so to break down how he ended up as the face of all these playlists on Spotify, even in genres that he doesn't make music within. He could do that. And that's another thing I don't like about this. This is why I'm so far away from this idea that Drake is doing this for artists and he's doing this to change the music industry. This is the part that feels self-serving, because these particular arguments, he can use himself as the example. He can throw himself on the altar of public opinion. He can be revealing, he can use his own text messages and emails as discovery to show UMG's deceptive practices. But he's not doing that. He wants to see Kendrick stuff. And that's
Tomato.
UMG's failure to disclose its scheme, along with its own false statements, fueled the fire. Artificial streams boosted the recording status on Spotify, causing consumers to listen to and prioritize the recordings under false pretenses, which in turn tainted their streaming data and used to proportionally allocate and disperse payments, causing Drake additional pecuniary harm, financial harm. Drake was also harmed as a consumer of music. Drake was also harmed as a consumer of music. That's so funny. Also, Drake was forced to listen to Not Like Us all the time. All the time he had to hear about him being a colonizer, reminded that he smacked bellies with Lil Wayne's girlfriend while Weezy was in jail. He had to hear about all of his awful friends and how Party is at the party playing with his nose now. He was so harmed as a consumer of music. 1 second applause. Kendrick Lamar is a great writer, man. Fantastic writer. UMG contends that Drake's theories of harm are purely contingent on harm to consumers and are therefore not cognizable. Not so. While courts have held that a plaintiff lacks standing to bring Section 349 claims where a plaintiff claimed loss arises solely as a result of injuries suffered by misled consumers, see End State Autobahn, that bar does not apply here. As here, plaintiff's alleged injury did not require a subsequent consumer transaction. Rather, it was sustained when consumers were unfairly induced into taking their businesses from plaintiff to a competitor, regardless of whether the consumers ultimately ever suffered pecuniary injury as a result of the defendant's deception. Pecuniary, again, is financial. That is, Drake suffered harm through diversion of royalties, irrespective of whether Spotify users or radio listeners also suffered specific pecuniary harm. 3, the amended complaint adequately pleads second-degree harassment. Although there is a split in authority as to whether New York law recognizes a civil claim for second-degree harassment, application of the relevant tests and the weight of authority favor implying a private right of action for Section 242.6. New York courts use a very permissive standard to determine whether a private right of action exists. The test is, 1, whether the plaintiff is one of the class for whose particular benefit the statute was enacted. 2, whether recognition of a private right of action would promote the legislative purpose. And 3, whether creation of such a right would be consistent with the legislative scheme. That test is met here because Drake is a victim of harassment, and allowing him to seek civil relief against UMG both promotes the legislative purpose while complementing criminal enforcement. UMG's argument is entirely circular because second-degree harassment is included in the penal law and therefore police may enforce it. A private right of action is inconsistent with the legislative scheme. But that argument, if correct, would defeat every implied private right of action in a criminal statute. The weight of authority also favors finding a private right of action for Section 242.6 footnote 15 is listed a bunch of different cases they're just referencing. None of the cases UMG cites analyzes Section 240.26 under appropriate private right of action standard or acknowledges the Second Circuit's decision in Galilea sustaining a civil claim for harassment. As for the claim itself, Drake sufficiently pleads that UMG, 1, engaged in a course of conduct or repeatedly committed acts which alarmed or seriously annoyed Drake. Seriously annoyed me. Guys, it's so annoying. Every time I go outside, they just keep pointing at me. They keep saying, they're not like us. They're not like us. They wrote they're not like us on my store in London. They're right, I'm not like them. I'm not like them. I'm a sue.
Tomato.
With the intent to harass, annoy, or alarm Drake, and 3, which served no legitimate purpose. Well, the rap battle was the purpose, and also Drake levied a whole bunch of arguably defamatory statements at Kendrick Lamar, his wife Whitney, and also he goaded Kendrick Lamar and told him to tell people that that he said he liked him young. Okay. UMG challenges this intent element, arguing that Drake pleads that UMG acted only within an intent to devalue Drake's music, but intent can only be evaluated by a trier of fact after the record has been fully developed at trial and not in the context of a motion to dismiss at the pleading stages, right? And so that's the biggest point. Whatever the takeaway anybody needs from this, the biggest takeaway here is that Drake's team is basically saying, yeah, that's cool what UMG said and all, but None of that matters at this stage in the process, so you can't dismiss this case. You have to let it go to the next step. You have to keep going through discovery, and then we can come back to it. That's the main takeaway of what we're hearing here. People versus Corey says, at this stage, the amended complaint sufficiently pleads UMG's intent to harass based on A, the volume, importantly, timing of publications, B, the harmful nature of the defamatory material, and C, UMG's relationship with Drake. With respect to legitimate purpose, to the extent UMG's actions ever had a legitimate purpose, such as financial gain, that purpose was corrupted by at least July 24th, when Drake's counsel directly informed UMG of the violence and harassment Drake was experiencing as a result of UMG's conduct, harm that UMG to this date has never disputed. Finally, UMG's argument that Drake's harassment claim runs afoul of the First Amendment fails. False speech is not protected, as reflected by the continued viability of the ancient tort of defamation centuries after ratification of the Bill of Rights. And New York courts often deny motions to dismiss harassment claims involving speech. Conclusion, for the foregoing reasons, Drake respectfully requests the court deny UMG's motion to dismiss an RJN. We did it, Brooklyn, we did it. 90 minutes later, 1 second applause. So that's the update. This is, again, Drake's team. They just want the court to allow this case continue to go forward. So we'll continue to watch this again, but if you're just catching up at home, we want to skip to the end. A petulant pop star decided he didn't like losing a rap battle and decided to sue over things that he did first. And so that's basically where we are. Let me know what you think about all of this. Let me know if I missed anything or misinterpreted anything from a legal standpoint. My name is Justin Hunt. Like, subscribe to the channel. Follow the Company Man on everything. Follow the Justin Hunt podcast wherever you listen to podcasts. It's all happening.
Justin Hunt is here, it's all happening. Justin Hunt is here, it's all happening. The mathematical breakdown of this mighty game of rap we in. It's boom bapping. Systematical culture views us radical, it's all happening. Shaking hands and dapping them. Life through the lens of hip hop, from trip hop to yes, y'all, you don't stop, you don't stop. Justin Hunt is here, it's all happening. It's all happening, yes, it's all happening. Justin Hunt is here, it's all happening. It's all happening, yes, it's all